You're good.
This meeting is called pursuant to the provisions of the Open Public Meetings Law. Notice of this meeting was sent to the Cape May Star and Wave and the Atlantic City Press, posted on the bulletin board in the municipal building, and has remained continuously posted as the required notice under the statute. In addition, a copy of this notice is and has been available to the public and is on file in the office of the municipal clerk. Would everyone please rise for the Pledge of Allegiance? Pledge of Allegiance to the flag.
Jim Barnes,
Present.
George Dick,
Here.
John Fusco,
Here.
Allison Morgan, here, Paul Mulligan,
Here.
Kevin O'Neill, he's absent, Tom Richards,
Here.
Lisa Rosselli,
Here.
Carol Sabo, here, Ryan Griffin,
Here.
Carol Ray Flynn,
Here. Okay, our first item are the minutes of the February 18th, 2025 work session. So everyone had a chance to look at those. I'm sure my colleague pointed out this one. Yeah, correct. That wasn't the small, no, it was this.
there are some grammatical.
That's something.
Yes. Well, I did adjust
So,
the
motion to approve.
Make that motion. Second.
Barnes,
Yes.
Dick,
Yes.
Fusco,
Yes.
Morgan, Mulligan,
Yes.
Richard,
Yes.
Sabo,
Yes.
Griffin,
Abstain.
Rosselli,
Yes. Okay, our first item here is Paul Mulligan, 159 Stevens Street, an appeal of the decision of an administrative officer. And I think. Yes.
Yeah, we've all, the attorney for the applicant, the attorney for Jack and myself have agreed that the members who normally can't sit for zoning board are gonna have to step down, so. We're sitting at the zoning board here.
Hello.
Good evening.
If you have someone testify, I'll swear them in, otherwise they're.
Okay.
Thank you.
Good evening, Madam Chair, members of the board. My name is Colin Bell, attorney in Atlantic City. I represent. So I know we're here for something a little out of the ordinary, which is an appeal of a zoning officer's decision to issue a zoning permit at 159 Stevens Street, block 72, lot 5.07. From our perspective, the decision to issue that permit was wrong as a matter of law. It's not a criticism of the zoning officer for issuing it, but it's your right, and in fact your duty as the zoning board to sit as an appellate body to determine if the issuance of that permit was correct or incorrect under your zoning ordinance and the municipal ordinance. And we think it was incorrect for essentially two reasons. First, what's not really in dispute is that this is in the R4 zone. And duplexes are not a permitted use under your zoning ordinance in R4. It's also undisputed that this is at least what purports to be a duplex, and to that in a second. So it's our position that you require a use variance. As you know, anytime you want to engage in a use that's not permitted in a zone, you need a use variance. The reason it appears this permit was issued was there's a grandfathering provision in your land use ordinance when the R4 zone was created. But we take a look at the language of that amendment, both your exactly what it says in your code and in the ordinance that adopted and talked about the reasons why it was adopted. And you think about the logic behind it, it's fairly clear, respectfully, that it was not intended to allow any use that occurred in the R2 zone to then occur in perpetuity in the R4 zone, like campgrounds and mobile home parks, 3 and 4 unit house buildings. That's not why the ordinance was amended. In fact, there wouldn't really be a purpose in amending the ordinance to allow or disallow certain uses, and you could then just do every use that was allowed before the event. And I know everybody can read, so I don't want to be pedantic about it, but I want to point out 8 few things. First, when we look at the applicable section, which is 13.8, talks about pre-existing vacant lots. Any pre-existing vacant lot of record that meets current zoning standards shall remain a buildable lot and shall not require an area or a bulk variance. These we said were a use variance. And I'm sure Mr. King will instruct you on this, but and I'm sure he'll correct me if I'm wrong, that when we're talking about how we interpret statutes, how the law is read, there's a principle, fancy Latin way of saying it is expressio unis exclusio alter veris. When you say specifically these things, it excludes other things. Right? If we're having a coloring contest, you don't use red and blue crayons. The rule says you can use red or blue crayons. Doesn't mean or blank. It says the two can be used. This says the 2 types of variances that will not be required. There's also the related principle, which is probably the easier way of saying it, is the specific rules over the general. If I specifically say these things that are not required in the statute, it means anything else is excluded by that specific reference. So, the plain language, which is if the statute is ambiguous, that's the alpha and the omega, beginning and the end. The plain language of the statute being determined the meaning, that's all you're losing. But we want to go past that and look, because I know you got compliments to your engineer on doing such a thorough job at this review. And when we go back to this memo, and a copy of the ordinance 302 from 2001 talks about why this was being done. And starting in the preamble paragraphs, we're talking about wanting to preserve a primarily rural and agricultural character of the area. But then gets into specifically this grandfathering provision in section 5 of the ordinance, so on page 5 of the ordinance. It's that any pre-existing lot that would otherwise be subject to the requirements of R4 that meets the existing area and bulk standards shall remain a buildable lot and should not require an area or bulk variance for development or expansion. Again, that makes sense. If the lot size in R2 was half of what it is in R4, 75 versus 15,000, and people created lots based on that size, they subdivided what was the buildable lot. So, okay, that remains a buildable lot. But it doesn't talk about use. It does talk about vacant contiguous lots. And it goes on to say, is the intent of this paragraph that these lots and uses existing at the time of this amendment shall be preserved as pre-existing lots and uses, and that, and this is the key, to the extent of their current development, they retain the benefit of zoning that existed prior to this amendment. To the extent of their development, it was a vacant lot then, and it was a vacant lot at the time the permit was issued. So the extent of its development was vacant. There was no duplex use. And again, I don't believe you could think it was the intent of the governing body at the time to allow everything that happened in R2 to continue to happen in R4. There would be no point in the ordinance. So I think we're pretty clear. I think the ordinance is pretty clear on its face. It's also very clear, I think, when you look at the legislative history, meaning this ordinance and what was being discussed at the time. And again, the engineer laid that out in pretty good detail. So we submitted it was incorrect as a matter of law to issue that permit. Certainly the property owner is free to seek a use variance to build a duplex. There's no one's arguing. She's not entitled to do that, but she would require a use variance. Secondly, we're asking if we're raising the fact that is this really a duplex? And your ordinance that defines a duplex as a duplex dwelling or two-family dwelling that which means a dwelling designed for the occupancy by two families in between the two dwelling units, which is a little circular because the definition has its own word in its definition. The word contain, I think, is the key there. And contain means to have within, look at the dictionary definition, talked about that in this letter, Merriam-Webster Dictionary, which New Jersey courts have cited over 100 times as the definitive meaning of what we're saying. So if you just have two back-to-back single-family homes that are connected in some way, I submit to you that that does not meet the definition of what of containing two dwellings. And we could get into some outlandish extremes of what you could call a duplex if they could just be two completely separate houses that where the garages touch and so on. So even if a duplex was allowed, which again, we don't think that it was, submit to you that based on the definition in the ordinance of what a duplex is, this is not containing within a structure two dwellings. It's two separate dwellings. You also have the power to interpret your ordinance and explain what that means as part of this procedure. So, again, I don't really like the law school. I didn't really like the lectures. I don't want to stand here and lecture you. I know you all can understand what this means. I'm happy to answer any questions. I think that's appropriate at this time. Otherwise,
The questions, but also you're going to hear from the applicant, so if you want to wait and hear their argument, and then you can ask questions by either one of them once more testimony is important. In my view, the board can always ask questions whenever they want, to the board. But if you want to wait and hear from Ms. Newcomb on behalf of the party that's developing, do that first, and then you can ask Mr. Bell any questions. Is that okay?
Yeah, so could we have the
thank you.
party move forward? Thank you.
Good evening, board members. My name is Lindsay Newcomb from the law firm of Monzo Academies to Lawless. I am here tonight on behalf of Lisa Barron, who is the owner of 159 Stevens Street. Lisa and her late husband owned this property since 1996. And Lisa began the process of getting ready to develop this property as long ago as 2022. In 2022, an application was filed documents were submitted to Norm Roach with some questions about what could be done on the site. In response, Ms. Barron received an email, which I have got for the board.
We have new documents.
And
I said, wait, we still have a new document?
maybe so, I said this must be her.
All right, that's-
I got it.
okay.
Thanks.
I thought it was new.
No, not good. It's fine. Let's get it. And I hope that there are copies there for the board, which there should be. But in 2022, Ms. Barron received an email from a West Cape East zoning officer that says, attached is the highlighted list of items needed to complete the zoning application that was dropped off at my office today, also attached is the COA form. This property is located in the R4 zone, but is grandfathered into the R2 zone because of the 75-foot lot frontage. Just FYI, 75-foot frontage is required for a 2-unit dwelling in the R2. However, the units must have a common wall or roof, not two completely separate buildings. With that information, Ms. Barron took on a significant development project. She filed in December of 2024 for a zoning permit, which was issued, and I think that was submitted with Colin's package, but if not, we do have copies. And then it was submitted in 2024 as an application, and in 2025, the zoning permit was issued. The zoning permit lists the zone as R2GF. One can assume, and assume your zoning officer can confirm, that means R2 grandfathered. It says permission is hereby granted to build a duplex as per plan dated 10/14/24. NJDEP permit approved 5/20/24. Grading plan approved 1/7/25. COA paid. My client relies upon those approvals, obtained road opening permit, and some shade tree permits, and utility permits to move forward with this development. Mr. Mulligan has since filed the appeal, essentially saying what I believe is that while the property is grandfathered, it's grandfathered as to size of use. However, that's not what the ordinance says. And I will admit, I don't mean to repeat it, Mr. Bell just read it to me twice. The ordinance is ambiguous. I will admit that. But what's not ambiguous is the intent of the ordinance and how it's been applied. The intent of the ordinance was to preserve open space in the borough by preventing the subdivision of large lots for residential development. The grandfathering provision was to allow the smaller lots in the R4 zone to be built in accordance with the R2 regulations. It wasn't to punish the owners of those R2 lots. It wasn't to harm them in what they could develop there. It was to make sure that the larger lots weren't subdivided. What you heard Mr. Bell refer to about campgrounds or developments of that nature is a red herring. There are no lots on this grandfathered list that could be developed in that way. This list was created to preserve the small lots, not harm the people that own them, but to allow them to be developed in accordance with the R2 standards while preserving the larger lots so that West Cape May was not completely subdivided. The committee expressly stated in their minutes that the commission, expressly stated in their minutes that it's not the intent to harm property owners that otherwise met the R2 requirements at the time the ordinance was adopted. When looking at the grandfathered property list, none of the lots meet the requirements to develop a single-family home in the R4 district. They either lack frontage, depth, or area. The larger lots that are on that list that could be developed in a more intense use, those lots don't have any frontage. They were included to preserve that farmland. Not only would excluding the uses from the grandfathering provision go against the intent of the ordinance, it's also contrary to how the ordinance has been interpreted in the past. There has been a duplex permit issued for the construction of a duplex on an R2 grandfathered lot by the borough in the past. I guess just two other comments and then just a little bit of testimony from Ms. Barron. First is that there's some references in the submissions about DEP permits. Ms. Barron did get a DEP permit. It said single family. When Ryan Anderson, who works for the DEP, was in correspondence with Mike Lucy, who was the environmental consultant, it was made clear that they didn't care whether it was a single or a duplex. They took no position on it as long as the footprint didn't change, which it hasn't. And the other item, maybe after now. Do you want to swear Lisa in?
Testify, yes, I do.
Yep.
Ms. Barron, please raise your right hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you God?
Lisa, you own the property that is the subject of this appeal, correct?
That's correct.
I know that I went through this briefly for the board, but can you just explain in your own words what you've went through in an attempt to develop this property?
Sure, absolutely. Well, in 2022 is when my sons and myself decided we were going to go ahead and develop this time together, and I lost my husband, and it took some time to regroup, but we decided to go ahead. And the thing that we did, of course, was go to the borough and say, let's confirm what exactly we did do with the property zone. It was very clear. We went to see the zoning officer, Mr. William Roach, and it was very clear that it was an R4 district, and your lot is grandfathered as an R2 for use, and well, you can go ahead because of your frontage. You can go ahead and also consider 2-family, which was great. That was very important to us. And from there, the first thing that we did, of course, is go to the architect. You know, that the plans that were drawn up based on 2-family dwelling. The DEP was the next step that had to be done, and of course, that's a lengthy process to delineate the wetlands. We did all that. After that was done, of course, I mean, financing was going to be based on a 2-family dwelling. After that was complete, we moved forward with grading plan had been submitted to the borough. Of course, that grading plan was approved by the borough's engineer.
We had to have a soil erosion plan complete. That was based in both the Barron Duplex, Cape of Conservation. Department gave us a certification for that. Check my notes, there's a lot, of course. And I don't know all of you are familiar with what you have to do, but I'm just going through, you understand that everything that I did was based on the two-family dwelling. I did the application for sewer, water and sewer, both applications, my fees are doubled. Why am I fees doubled? Because I'm building two-family. So, the cover fee was based on the assessment, I'm sure, based on the two-family dwelling. I can't confirm that, but just gonna put it out there. Landscape planning was approved, the tree weeds, the permit was approved, so everything was done step by step by step. At that point, it's January 2025. Mom said, you're good to go, there's no permit has been approved, just become taken up. What we did, the very next step is to get the street opening permit. And why I say this, there's a domino effect to it. There are a lot of people that this is affected. Okay, we get your street opening permit. I work with the gas company to make sure they come the same time as the street opening was done, so that we can go at the same time. Of course, that's all new now because that expired March 1st. I was issued a stop work order right as our grading was finished, which was the second, the end of January. So all of our grading was done, we were ready to continue from there, and I was issued a stop work order because my neighbor was no longer going to file a permit.
So Lisa, all of this to say, while this process was arduous and is important, all of this to say that you have owned this property since 1996, which is before the new ordinance went into place. And it was always your understanding that even though the zoning of your property had changed, that you were permitted to develop however you would have been allowed to develop when it was hardship, correct?
Absolutely, that's absolutely,
And that this was continually confirmed throughout your submissions to the borough.
absolutely, 100%. We've done everything I did.
I just looked at the submission and saw that the zoning permit and the application were not included. I do have copies of them for the board, so I should consider them as well.
I thought the record on appeal was all the documents that were in the zoning office was filed, so.
Yeah, that's fine. If I just take over.
I don't mind you doing it, I'm just telling you, I think that it's part of our record.
Yeah, you're right, it is. Oh, the board has.
They were given them electronic.
Okay, all right, then we're good. So that means that in the board's files, they should see the documents that I just referenced. I just incorrectly said that they were submitted as part of it. And I think with that, Rich, like, obviously we're available to answer questions. I think that it's probably important to hear from your zoning officer, and that we may have some questions from him as well, but at this point, it's all about
Can I
the.
ask two questions?
Sure.
First, I just want to tell my board that you're not citing an estoppel issue, so it's all relevant, I guess, in the sense that apparently your other administrative agencies were interpreting it the way that the way the snooping is describing it, and so it's relevant, but it's not a situation where you should decide a certain way just because they are moving along in their project. My understanding is the appeal was timely filed. I haven't seen any challenge about the timeliness of the appeal. So it's a timely appeal, and that's just, you're just making a decision based on your understanding of the ordinance, not an estoppel. You're not even allowed to make estoppel decisions. That's what it is. So I just want to get that out there. Nobody feels bad. Everybody doesn't feel bad, but it's just not a decision that leads them to do action.
And I agree, the purpose was not to make a stop argument, the purpose was to make clear that the rest of the borough was interpreting it the same way by issuing these pleas. So that's all.
If I didn't say that, I meant to.
Yeah, no, you did, I agree.
The one thing that I was raised by Mr. Bell, and I think it was something I raised a few days ago, was a question that I had, which is when the board did the grandfathering, they didn't include a duplex as a permitted use, but that's not the only use they didn't include in the new R4. They also eliminated multifamily and I think mobile home parks. There's like a list of things, 3 and 4 family dwellings. Is it your view that if there was a lot that was of sufficient size, or if it combined with another lot and someone owned 2 lots together and they combine them, that they could then build a 3-family or 4-family dwelling or mobile home park or whatever other the permitted uses were? Do you believe that was the intent?
I don't know that that was the intent, largely because there aren't any lots that meet those requirements. So it's really kind of a rhetorical question. Could someone combine lots if they bought a bunch of lots that fell on this grandfathered list that created a cumulative total that allowed for a campground, and there was a campground license available in West Cape May? Then yes, that's my understanding. But I don't know that that was the intent because that didn't exist at that time. But my understanding of the intent is that whatever was allowed under the R2 zone on these grandfathered lots is how they are to be interpreted now.
Why do you think they didn't just leave all the permitted uses in the R4 then?
Because they wouldn't have met the lot sizes. Because that would be penalizing these smaller lot owners, because the R4 bulk regulations are different.
No, I'm just saying, like, why would they delete those other 4 or 5 things? Why not just leave them in there? Because if there's no lots that needed them, then why delete them?
Because why include, because maybe that's not what they wanted. They might not have wanted to include them as permitted uses moving forward. I can't speak to that, but what I can speak to is what we believe and what Ms. Barron has been led to believe and the zoning officer has believed was the intent of the ordinance. But again, I think that question is leading the board to worry about issues that don't exist because that's not possible right now, given what's here. So to concern them about a campground is not a fair.
I don't know if there's contiguous lots owned by the same people. I mean,
That could change at any time,
yeah.
right? Sure.
So if someone does an assemblage and wants to put a mobile home park in the zone, I expect there'd be concerns.
Perhaps.
And then they would say, well, yeah, you grandfathered all the uses.
Yes.
Anything further, or does anyone have a question? Do you think it would be appropriate to hear from our zoning officer?
I do have a question for Mr. Bell.
Oh, go ahead.
Sorry. Yes.
I don't remember your exact order, you said something that,
I think it's microphone, please.
I don't remember your exact phrase, but you said something along the lines of that, in your view of the change the zones, that you said something like it wasn't the intent of this, change to penalize, current owners. That was not coming, that sound, that.
Yeah, it was not to harm the owners, is that I think these sometimes would be.
Okay, well, that was my question from is just if you could, I'm gonna have it here and repeat it, but is there a reference that you think is
I think that you likely will hear that from your zoning officer, but I do have meeting minutes and I just think.
I also hint this is actually my question to ask you. This part.
Two sets of meetings. One is. Not two.
I think it's in the question and answer sort of room.
At the end, I was gonna say,
Yeah, I think the public is speaking, and I think Ms. Hinkler may say it.
yeah, I just am looking for. Oh, it's here, it's during public comment, someone, it says, John Ostrowski, 737 Sunset, asked about the grandfathering of lots, Mr. Rossi responded that the ordinance acted not to harm residents, but to right, wrongs done in the past. That was the, and Mr. Rossi was the borough solicitor, he would have answered that question. And the other thing, I apologize, I know that I had started to say something and forgot it just a second ago. It was about the argument of this property, this not being designed as a duplex. And I'll be brief on that because I think that your zoning officer lays it out clearly in his memo. A duplex is defined under the borough code as a dwelling designed for occupancy by two families containing two dwelling units. And a dwelling unit means a room or series of connecting rooms with a living, cooking, sleeping, and sanitary facilities for one housekeeping unit. And that's exactly how this is designed. It just has, are touching, and they're designed to be separately occupied. They all have bathroom, kitchen, living room, all of those things.
Are any of those things touching?
Yes,
Where?
the garages are touching.
That's not on that list.
It doesn't mean that those things have to touch. Doesn't mean you have to go bathroom to bathroom. It just means
I
that
respect
the
your-
buildings have to touch.
Well, I would say that someone may be of the opinion that living quarters should be touching.
I
And
mean,
that's why those things are living areas, not just the two corners of a house. What if the two garages weren't touching like this, but rather just the points of the two corners of the garages were touching?
it's not what this says. It
Well,
says
I know, I forgot what
duplex.
it says. If it said it perfectly, we would have 100 people spending their Tuesday night here.
It's
So
a duplex
obviously he said
or
it well.
two-family dwelling means a dwelling designed for occupancy by two families and containing two dwelling units. These are two structures that are designed for occupancy by two separate families that contains two dwelling units. Doesn't say that those dwelling units have to touch living quarter. It's garages, houses. The lot, I think as you've seen in plans, I mean, I'm a zoning environment, the lot is narrower but long. Right, so designing them in that way maximizes the space that was usable, especially given the fact that there was significant limitations put on the property by DEP, which is what you saw the permits on as well. We had to design it close to the front of the lot while using what we had in terms of a more narrow property.
I have a quick question. I think a few months ago, didn't we have a more specific definition of what a duplex was going to be, and wasn't that adopted in the minutes? That's going back a handful of meetings, though, like maybe 5 or 6. I think there were specifics as
actually
to
think we
what
would-
a party wall would be.
I thought that we clarified the definition of dwelling unit, not duplex.
I think I know what you're thinking about, and I reread it also. Like, we had a property where someone it was a single family residence, but they had two sort of separate living rooms, and they connected them by a patio. So it wasn't a duplex. The question I had was whether it was two principal uses, merely, or was it one principal use? And we had a whole rigmarole with James Chadwick was the engineer, and we kind of finagled it where the thing that was between them kind of developed walls. It was kind of like just an overhang, and then we made them on walls and screened in, and over half of it being a wall, like walls on the side to try to connect these two things to make it a single principal use, but that wasn't a duplex. Now, we may have had a conversation at that time, because this is an issue that I've dealt with here in May. About what it really means connects them. And as soon as they're connected, it's not an accessory use, it becomes part of the principal structure. And I've expressed concerns about what really that connection needs to be for it to be part of the principal structure, because I just don't think just a simple room connecting things makes that part of the principal structure. Here, your question is different. Okay, this is what is a duplex. So council, Ms. Newcomb correctly points out that our definition is not great, okay? But it does say the word contain. So what does it mean to contain? And then the other definition that Ms. Newcomb read about what is a dwelling, and when you read that part of the dwelling, it doesn't really talk about the garages, which are non-habitable areas where you store cars and other things. So the question is, what are they talking about being contained in the same building? Is it okay if the two buildings are just touching somewhere? Or do they have to share a common wall of living space, vertical or horizontal, such that it looks like a single structure, if it contains in a single structure as opposed to just two houses kind of touching in some way? Whether that's what that meant by duplex. And that's a decision that I don't make. Decision you made. Your ordinance does not give you as much help as some other ordinances. Mr. Bell either mentioned in his paperwork, I don't think he mentioned it tonight, but it's in the letter that you've all seen, I think, that says that DEP has a definition that is more in line with the definitions that I've seen in other places where it talks about a vertical, horizontal, shared wall of living space. Like duplexes, you know, the living rooms against the living room kind of thing. There's a little more creative design and maybe your ordinance allows for this design and you got to change your ordinance, but that's part of what you're going to interpret and decide tonight. Okay, so I don't have a position either way on either one of these issues. That's not my role. I just want to make sure you think about all the right things so that our record has all the right stuff talked about. And then you guys decide and articulate your decisions. And it was up to me. We wouldn't have the zoning board judgment. So just bring the information and decide.
Did you have a question for Mr. Bill?
I did. Well, if the purpose of this thing was to not harm the residents who own R2s, and a lot of them seem to have a sufficient area to have a duplex, isn't it kind of misleading to tell them you're not harming them, but then to amend the ordinance in a way that lets them not be able to have a duplex?
Yeah, two things.
Part of the market for the record, in case you're.
If we can see.
Have a record with one. I'm a note taker and I make sure there's a record. It's kind of like
I try to take notes and then 2 minutes later, I can't.
that. I take it.
I think 2 points of that. One, I mean, that was an isolated comment in a 20 different person colloquy that one solicitor made to this person saying, hey, we're not trying to hurt you. I don't know whether that's specifically evidence. Right. However, when you're talking about not harming someone, I think the logic behind it is kind of what I said before. If these lots were created, we're not going to make them unbuildable lots where you would need a bulk variance because these lots were created at the time that was the minimum lot size that's required. That's different than saying we're not hurting you. You're still gonna have a buildable lot. You can still build on it, but you're going to need it. Doesn't mean you don't need a use variance once that use is no longer permitted. As with every zoning ordinance, every use that's not specifically permitted is prohibited, and you change use. The ordinances are amended all the time to change use. I'd also say this is the other last point. And I think you had a very astute question on well, where does it say that? The ordinance itself says what the intent of the ordinance is in the preamble. It's talking about preserving the rural and agricultural nature of the zone. So we don't need to look to what one person said in one public meeting and say, well, by not harming that, then everybody can do all prior uses before forever. The ordinance says, well, that would be inconsistent with then allowing you to continue to use those uses. Hopefully that answers your question.
It does. The only other thing that is on my mind is that if they were looking at the lot sizes and deciding what uses to include in the new ordinance, there were lots that could have duplexes. So they should have just made duplexes a permitted use. Still, I mean,
Well, and I think that was kind of my point. Is when you say what uses you want to be allowed, you put those in the ordinance. These are the things that we want to be allowed. And if they wanted to carry over duplexes, they could have easily said that. And they could have said, area of bulk or use will not be required. They didn't say that. They said area of bulk.
do you think it's relevant that it seems like our zoning officer has interpreted that grandfathering that way? Is that a relevant consideration with the board that they seen their course of conduct was that that's what that did?
Well, I guess I shouldn't waive the attorney-client privilege, but, I was having a very brief conversation with my client right now saying, Mr. King just mentioned something I was gonna have to get up and say, which is, you can't invoke a stop. It doesn't matter, that there was a alleged statement that it's okay, or it's been interpreted that way in the past. Stop wasn't run against the government. All that matters is what this ordinance says. And it's that, again, I think it's the plain language, number one, and even if you get past the plain language, it's the intent, based on what the ordinance says, its intent is. And then three, it's the logic. So what one person said while they were doing, why they were issuing a permit, I don't think impacts the board's decision. The board is here to decide if that decision was correct. If we said it's okay because the zoning officer did it, it would negate the need to have this body sit as an appeals tribunal to decide if those decisions.
And we have at least 3 lawyers here, like, you're standing there now, and,
People say it's 3 too many.
rib shot, right?
The client's the biggest issue.
What if this is just hypothetical, but it'll help me understand where this grandfather stands. If the Barron family what if the Barron family had just purchased this instead of having owned it since it was R2? At what point and how many sales and change of hands would a vacant lot become R4 with regard to use? Or would it remain R2 in perpetuity? Because that seems to go against the intent of the change in zone too. I mean, we have some vacant properties out there.
I believe, and obviously, doesn't even speak for himself, but I think we'd have to stay under their interpretation of perpetuity, which is against how, zoning is not concerned with ownership. It's concerned with use. So you can't have a rule that says, well, as long as you own it, you can do something, but if you sell it to somebody else, you can't do that. You can do it with key restrictions and private art sales. But the zoning ordinance has to be neutral to ownership. So if they're right, that doesn't matter. You can sell it 100 times and they'd still be able to do this. That's correct. You can't. It doesn't matter who owns it. It doesn't matter if they've lived for 200 years, they bought it last week. Because it's grandfather's by lot.
But has it been subdivided previous to the change in zone? They would still be able, I'm not sure I'm getting this.
Sure. So here, to be very clear, I think it doesn't matter who owns it. You can't put a duplex in. It doesn't matter if she bought it last week or she's owned it for 100 years. You can't have zoning rules that depend on ownership. So it wouldn't matter. You either can or you can't.
Okay, but someone that owns 150 feet out there, what prevents them from now subdividing the 350-foot lots, which are not situated in R4? If it wasn't previously subdivided as a grandfathered property.
And they'd have to apply for variance, I guess.
Why wouldn't that be?
Right again. So my position
That's
is,
asking the wrong attorney.
yeah.
Well, yeah, there's a bunch of attorneys.
No, it's new.
You
He
probably-
agrees with you. He doesn't.
Yes, you
Well,
are
I'm
the same.
just trying to understand. Yeah.
Ask the one that disagrees.
So I,
I actually like what you're.
No.
That's
as it works. So the answer to that, I think, is twofold. Again, in these meeting minutes, was that included in the zoning file, the meeting minutes for the ordinance? Okay, so in those
I
meeting
think
minutes.
it's best to make sure that everyone saw the same document.
Right. So the meeting minutes say Commissioner Gaither reported that the process will be put in place whereby the zoning official will have a copy of this ordinance in each file by block and lot, stating that the grandfathering clause and thereby following through not just by owner but by lot of record. So this applies, it runs with the lot. There was a list that was created. Every grandfather lot that existed at the time that the ordinance was passed. So doing a subdivision now doesn't grandfather those lots, and they didn't exist. The goal, again, was not to harm the people who owned those lots that are now not in compliance with the zoning code. The goal was to allow them to be constructed. They were grandfathered in. They exist on a list that says the block, the lot, the frontage, and the depth on them, right? So it gives you those dimensions so that you can reference what was permitted in the R2 district, cross-reference it against this list, and then you were grandfathered into those standards. So if you subdivided now, you wouldn't get the benefit, so I agree with you that that wouldn't make sense. But the logic was that it would run with the property, and that because even if you sold it, those people deserve to retain the rights that they had. There's monetary value in being able to develop a property in a certain way. To not harm them, you had to allow them to continue to develop. And again, I think probably all of this was included in the file, but I'd like to see I have
Thank you. Be appropriate for, oh, I'm sorry,
Yeah, and apologies if I'm missing this, but what was the date and maybe the decision about you mentioned there was a bill, that was granted for another duplex in the R2 GF?
Yeah, not an appeal, there was another zoning permit that was issued for the construction of a duplex.
I see, okay.
was there only one or were there more?
There was one. It's one, that's fine. There's only been one application to do it, so it's not that someone has been denied. It's just- And
Okay, so just to clarify, there has been an instance since the rezoning where somebody did the same thing, applied, got permission from zoning and proceeded.
in 2008.
Okay.
And the ordinance was enacted in 2001, so obviously it's 18 years later.
Thanks, that's it.
Just to clarify this, so someone owns 150 feet out there. And, the minimum size is now, they never subdivided, it's still 150 feet, the minimum size is now 100-foot frontage. They argue that they can have 350s because they're being penalized.
Could someone come to your zoning board and ask for relief in that way? Is that?
Yeah.
As someone who's not on this list?
No, we have a zoning.
No,
Hold on, I think you guys are kind of talking.
planning board. Planning board.
They get a by right subdivision 350 saying, we're in the R2, so we should be able to.
We're grandfathered in the Arctic.
No. The ordinance specifically calls out the lots that are grandfathered. Could someone come before you and make that argument? I guess that would be for you all to decide whether it was appropriate to grant them variance relief, right? It wouldn't be that they could do it by right because other people were grandfathered. It would be them coming to you and saying, can we have variance relief for lot frontage, lot?
Well, I was asking about the grandfather. There are lots that are grandfathered that are, bigger than,
Oh, I'm sorry, I thought you were asking if somebody.
no, I understand they would not be, but.
Right. I don't know the answer to that. I guess the answer to that is, it says what their frontage and what their depth are. So I would presume, although I think that this board has held in the past that a lot line adjustment didn't change the grandfathering R2 status. And I'm reaching a couple years and a different attorney in my firm. So I'm reaching a little bit, but I think that this board previously allowed for one of these lots to have a lot line adjustment, which altered the width and depth, and they still received the benefit of the R2.
They pre-existing
Grandfather.
homes.
I don't know.
I don't think we should get too far into that, unless someone's
Yeah.
gonna show me the resolution, I don't think we should keep that, that's kind of like.
All right, thank you.
Um. Chair, you decide. You want to ask them first? Yes.
Your advice is, we'd like to hear from the public first, I suppose. Yeah, but, yeah, it seems even better. Engineer report.
Thank you, Chairman. Both attorneys pretty much covered my interpretations. I just want to preface any testimony that I give that I am trying to read behind the lines and trying to read intent. So my letter is by no means wordings or wrong. It's just another puzzle piece for you guys to help shape your decision to make a determination for the court. As Mr. Bell stated, I'm in agreement with his position that specifically, if you look on my page 2 of the engineering letter, it says those lots and uses specifically existing at the time of this amendment, which is the 2001 ordinance, be preserved as pre-existing lots and uses, and that to the extent of their current development, they retain the benefit of the zoning that existed prior to this amendment. Again, I'm just reading the ordinance as it was written 24 years ago. So that is my stance. It's not fact. It's just another piece of the puzzle that help you interpret this ordinance. As it pertains to the duplex interpretation of that zoning ordinance, I agree that a duplex with Ms. Newcomb, that a duplex is a duplex dwelling or two-family dwelling shall be a dwelling designed for occupancy by two families, which it does, and containing two dwelling units, which I believe it does. I know Rich said that it doesn't have any living space that butts up against each other, like a bathroom or a living room or a kitchen. But if you were to take their design, that's right now to living quarters with a garage in the middle, that they don't share a firewall in between both of those. If you were to flip both of those 180 degrees, would that just magically make it a duplex now because they shared that wall? Make that determination. I believe that the way that it was designed fits this specific definition of what a duplex is. Not to say that we can't change it in the future, but that's how it's written here. That's pretty much all.
So you're saying that their design fits our current definition?
That's my
of the
interpretation.
Okay, thank you. Okay, so we're going to open this to the public. If there's anyone within 200 feet of this project that'd like to speak, welcome to come up.
The way it's gonna work is you're gonna state your name, spell it, and give your address. But first, I'm going to swear you in. Okay, so I'm gonna swear you in, then say your name, spell it, and your address. Thank you. Sir, do you swear affirm to tell the truth, and the truth, so the guy?
I do.
Yeah.
My name is David Schultz. My wife and I live at 715 Sunset Boulevard.
Sir, I'm gonna do this. You're gonna state your name, you're gonna spell it, and then you're gonna say where you live.
Schultz, SCHULTZ.
Thanks, sir. You're gonna be famous in a resolution and what your name's spelled right.
It's usually spelled wrong, but thank you.
Out there, address?
715 Sunset Boulevard. So we are catty corner from this property, or from the back side of our property, because we face Sunset Boulevard. And they face Stevens. We bought the property in 1995. We built our house in 1998. It's been our primary residence for the last 27 years. This is, I don't know if you know this, you probably do. This was Robert Franklin subdividing this property into 8 parcels. Some four facing Sunset, 4 facing Stevens. And they were all too narrow. Right, they were all less than 100 feet. But it was approved, and we all built, all of us, all 7 of us have built so far, built single-family dwellings. Excuse me. So one of the, I should say too, I am a licensed architect in New Jersey, and I've been before hundreds of zoning boards before. I don't agree that this is, by definition, a duplex. in my personal opinion. I think it doesn't agree with what Google says is a duplex, but I also don't agree that you can separate two houses by non-inhabited space that doesn't count towards FAR and call that a duplex. I think that's really stretching the world. So they have the benefit, unlike us, they have the benefit of an increase in lot coverage as an R2 property and a benefit in FAR, floor area ratio. So they have lots of benefits in terms of how big a house they can build that we didn't have. I guess I wasn't aware that there was a zoning change, that there was a grandfathering to R2. I don't know exactly why or when that happened, but it seems odd to me. I wish that this applicant would just build a big house, since they have the ability to build a bigger house than we did. I want to build a bigger house, especially if they want to rent it out. So I think, as somebody had said before, it seems to me that to turn this lot into a two-family lot is really out of sync with the neighborhood. Because all of us have single-family houses on lots that are, fairly close in size. So it's a bit of an odd duck to me. I also think unfortunately, it's also odd because of the way it's designed to be stretched out, to be two houses, boxy houses connected by two garages. I don't think it's going to be very attractive to any of the neighbors, I hate to say. I hope that, the board will also realize this adds traffic and more noise in the neighborhood on a street that's already very heavy with traffic. I hope somebody will take that into consideration. So, thank you.
Thank you. Is there anyone else within 200 feet that would like to come forward and speak?
Sir, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I'm sorry.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Okay, please state your name, spell it, and then give your address.
yes, James Atkins, we live at 713 Sunset Boulevard. And our property back.
Sir, you got to start over again. You got to do this in order. Please, everybody, please listen to the directions. You're going to state your name, then you're going to spell it, and then you're going to tell me your address.
Well, I think James doesn't need spelling, but Atkins is
You'd
ATK.
be surprised in this day and age, they go like JYMES.
I was born a little before that time. James was spelled JAMES then, I think generally now, but, and Atkins is ATKINS.
Thank you, sir.
Okay,
Address.
address is 713 Sunset Boulevard. And, we are, neighbors with, Dave Schultz, who just talked to. And our property backs up to the properties that we're talking about, and will be about a half a lot or so from the back of the property in question. Dave gave a fine discussion, and the only point that oh, and I might say one thing. I'm not an attorney, but I am a consulting engineer. So I look at this property from an engineering standpoint as opposed to perhaps other approaches. What I'm hearing, I believe, is there are two questions. One is whether the property is grandfathered to have multi-family properties. That's one. I'm not going to address that. The other is that a duplex is a usable option for the property. And I would argue that, this is not a duplex. And I haven't talked to all my neighbors, there are a bunch of us back there. We are not against development. We are not against land usage. But what we saw, I was not concerned until I looked at the drawings. And what I saw was two, 3-story high houses, one in the front of the property, one in the back of the property, and they're separated by 48 feet. Now, to me, that means the property is being used for two separate houses. You can get into a definition of what the garage piece is in between, whether that attaches them or not. But the fact is, from our property and from, all of my neighbors' properties, we're going to be looking at two houses crammed onto a very small lot. So when you ask what a duplex is, and that question has come up several times here, well, I went to the internet, and I came up with essentially the same definition through 3 or 4 different sources. I won't go into it very long. It just says, this one was from Zillow, which I thought was relevant. And they say a duplex is a property divided into 2 separate living units, okay? These units can be separated side by side or stacked one on top of each other. And I will reread that. Side by side or stacked one on top of each other. And they are typically share a wall in between. If the units have one floor, then the 2 units are stacked like this with a common wall between them. If they have more than or the other way is that they can be stacked one on top of each other, sharing a common floor. Now, the properties that have been, the drawings that I've seen don't show that. They show two separate houses. I can't imagine if, when we built our house in 1994, if I had gone in and said, okay, this is my house, this is what we want to build, and no one wasn't there then, but whoever was would have said, okay. And then I said, but wait, I also want to build the same house backwards over here. And I think the response would be, you can't put 2 houses on the same piece of property. And then I said, oh, well, maybe I'll put something in between so they're connected, so that makes it okay, right? Well, no. You still have 2 3-story houses on that piece of property. And I think that's mostly what the neighborhood is concerned with. We think that it's not the proper usage for that property. I probably could go on a little bit more, but I think maybe I've made my case. Again, I don't think that's a duplex. We don't think that's a duplex. We think that's 2 separate pieces of 2 separate houses being built on the same. And we don't think that's appropriate for that piece of property.
Thank you.
Thank you.
Is there anyone else within 200 feet that would like to come forward?
Robert, Robert, Elwell, Jr.
Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your address?
709 Sunset Boulevard, previously 151 Stevens Street. So what I believe the intent of the ordinance,
What do you mean by that? You said the address changed or you moved?
no, I actually also owned property at 151 Stevens Street at one time. I was just trying to lay a little groundwork.
Go ahead, that's it.
Yeah, I believe the intent of the ordinance was to minimize growth in that area of town. Just by the wording, the way that it talks about how people wanted the borough to look in the future, and also the one thing I do believe that the intent was to minimize it. The grandfathering, I believe, was the frontage of the property to build something on it. Because when I owned 151 Stevens Street, I didn't have the 100-foot frontage that was required to build a single-family dwelling. And a duplex or two-family, it wasn't an option. I was grandfathered into building a single family with a lesser frontage on the street, which I would have to think that everybody else on the street believes that too. Trying to think, I think that was just my concept of the whole idea. When I got the letter about this hearing, I thought it was for a variance, which I would totally understand if they're trying to build a duplex in a part of town that's not a permitted use. Then you go through a use variance to be, and I totally get that, but then I was told that it wasn't a variance, it was already approved, so I was kind of thrown for a loop. I think that's all I have to say,
Thank you.
unless there's questions.
Is there anyone else within 200 feet of this project that would like to come forward? Okay, seeing none, is there anyone outside of the 200 feet that would like to come forward?
Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. My name is Ed Belsky, Belski. I live at 7 Douglas Avenue, which is just about 25 feet out of the 200-foot property owners list. And I believe that I will be able to see the building that they're proposing to build from my front yard. And so in preparation for this meeting, I read the ordinance, I read the code, I read the engineer's letter, and I have to say I agree 100% with the way the engineer interpreted the code as it applies to this project. When I know a lot of people here have talked about their understanding of what the code means and what other people have said at different times, but I think the code means exactly what the words say. And I'm a professional engineer, and I've been involved with boards before and writing codes, and I know these words are very carefully crafted. And I think that if this code intended to grandfather use, they would have put it in there. The fact that it's left out is not an accident. And if you look at the ordinance and the citations, the recitations in the front, the board talks about their concerns about the threat of development and how it can change the character of the community. And in order to mitigate their concerns, they're enacting the R4 zone, which will eliminate multifamily dwellings, and it will make the required lot sizes larger. And that will mitigate the impact of
development on the character of the community. So it seems contrary to what the purpose of the code is, to then go and grandfather 61 lots that you can build fourplexes and triplexes on. I think that would be totally contrary to the intent of the R4 zone. So the other thing is, I think whatever the board decides tonight will apply to these 61 lots. And on my street, 2 of these lots are next to my property. And so I really don't want to see multifamily built on my street. I think that at the time the R4 code was written, the board did not want to see multifamily. And I don't think the residents of the area want to see that in there.
Thank you. Anyone else outside of 200 feet, like, anyone that would like to finish?
Affirm, tell the truth, don't truth, nothing but the truth, so help you God.
I'm Catherine, Pamkaithern, 207 Stevens Street. I'm not within 200 feet. Ordinance that's in question tonight was developed and adopted a few months after I became a member of the West Cape May governing body in 2001. At the time, as now, many residents were alarmed and frustrated with the rapid development in West Cape May, and particularly the effect it was having on the larger tracts, the land that was west of Bayshore Road. Much of it which was and still is environmentally sensitive and farmland. At the same time, there were concerns that enlarging minimum lot sizes would devalue existing smaller lots for about 30 properties in the same area. There was a concern that rezoning could potentially render those properties undevelopable or unable to be improved without an expensive variance and no guarantee of approval. We listened. And rather than piecemeal an R4 zone, including some lots but not others, the grandfathering language was included to protect the value of these smaller properties by retaining the rights of an R2 zone. It was intended to protect both their lot sizes and their lot uses. Had it not, a vacant lot, for example, may not have been able to be developed or would require those expensive variances, which could devalue the property and be difficult for those of moderate means. We, or I, did not want to see properties and property owners with smaller lots lose value as a consequence of protecting larger lots and larger tracts of land from being chopped into small lots. The ordinance was passed. Letters, as you heard, were placed into the borough block and lot files for the affected properties to ensure that in the years to come, the 30-some affected properties would retain the function of the R2 zoning, a practice which I believe has been followed for nearly a quarter of a century. Thank you.
Ms. Gaither, can I ask you a couple questions? If someone owned a single-family house on one of these lots and they wanted to demolish it and build a duplex, would they do that?
I'm sorry, could you say that again?
If someone owned a single-family lot in the R, what is now the R4 zone, a single-family, well, the single-family home on it, Could they demolish it and build a duplex?
One of the grandfather,
Yes.
theoretically, I believe they could.
Could they build a 3-family unit on it?
Because that would depend on how much land they,
Let's assume they have enough land. Did you intend to have a 3 or 4 unit?
the uses were to carry on the smaller lot sizes. The uses were to carry. Because otherwise you'd be taking away the value of the property.
Well, why not leave all
Maybe
the,
there were,
then why delete the uses? Well, what, I mean, because the old ordinance had 5 uses in it, the new ordinance has 2. Why not leave all 5 if the uses were gonna continue into the zone?
the R4 deleted the uses.
Right,
It was my belief that by grandfathering, using that term, because that's what a lot of people understand, but by allowing the lots that were there to retain the R2 status, maybe it should have been done differently, to protect those rights of those properties. But this was, as I said, I've been in office a few months, depend upon professionals to tell you how to manage what you're trying to do. The goal and objective, and you've heard me before this board and many times since then, is preserving the character of the town. And part of the town does have small lot sizes. There are some small lots and some that were developed like, many of the small lots that were on that list were created. And they were owned by people that lived here, that worked here, that raised their children here, that invested here and plan to stay here.
how many people vote, it was a board, it was a 3-person board,
Yes,
you were one of 3 votes.
correct.
Was the vote unanimous?
Vote was 2-1, and I'm sure you've seen the ordinance in your packet. And in the minutes, as I reviewed them as well, there was a concern that the questions that the planning board had raised had not had a time to air, and that was the understanding of why the third vote was not in the affirmative, according to what the minutes say. I mean, it's 25 years ago. I couldn't tell you exactly what was said that night. I remember the flavor of the board, remember how many things went with that board. I think there was also a comment in there by the no vote that they didn't disagree with it, but they thought there should be more time.
Do you believe the current ordinance as written reflects the intent you just described?
I can see where there's questions how it's written. Someone had mentioned earlier, 3 attorneys in the room, 3 different interpretations. I mean, you can take anything and find different ways to interpret it.
Building 2 different interpretations, because I agree with one of them, not the other, but I'm not saying which.
I do believe that the ordinance has been interpreted the way it was intended to be interpreted. One of the other
I
things,
told of one instance in 20 years where someone did it. Are you aware of others?
I'm aware of others in town. I'm not aware of others in that particular zone, but throughout town, there are a number of
I understand this is kind of, I'm just trying to see if you have a history that you can share of the ordinance being interpreted the way you're describing it. So I'm only hearing one duplex in 20 years.
But I'm also hearing from the what is the defense?
The homeowner, the property.
There were other instances where the ordinance was interpreted and, a lot line was moved, but it still retained the use. I mean,
I just heard what's, you have this wealth of knowledge, I just thought if all these lots could be duplexes, I would have thought we would
yeah,
have heard.
but I wasn't a zoning officer. I can only tell you what was the intent when it was presented and adopted. And again, it was shortly after I had been elected, and I believe a good part of that was because the flavor of the community was we wanted to see larger tracts remain as best we could, and never wanted to hurt the people of the town.
Thank you for answering the question.
I have a question.
So how were these lots selected? Was it every smaller lot was grandfathered, or were there some that were not?
It would be any that wouldn't fit the new zoning size, which was the 100 by 150, right? Yeah, so if they didn't hit that, then they would be on
They
that list.
automatically
They
became.
would be on that list, yes, whether they had been developed yet or not.
Thank you.
How many lots aside from the list that were too small? I mean, how many total are in there for everyone?
I want to say it was in the 30s.
There's like another 30 that comply.
Yeah, I heard a number 60. I don't recall that. I mean, I honestly,
I'm just trying to figure out the percentage between, with the smaller lot, like, trying to make this, the R4 zone, like what actually applied already and what these small.
I remember seeing in the minutes, I'm a research person. I went back and I looked at how much acreage was involved in the new zone versus what would have been grandfathered. It wasn't necessarily a matter of how many individual lots, but how large of an area was going to be affected. And it was, who has that in the minutes? Anyone? It was huge. It was a couple hundred, I mean, let's say so.
I think I have the answer for you. Is that okay?
Yeah.
And, Mayor, this is what you said it at the, this is what you said at the map needs to be correct, 35 lots with less than the 15,000 square feet need to build the 323 acres, approximately 7.6 acres would be grandfathered, 177 acres conforming, approximately 7 acres not.
I continue to say that. Well, what was your question and what's the answer to it?
Yeah, no.
What's your answer? Okay.
Can I ask Pam the question?
And you want to answer a question?
Hold on, if we're gonna do this, you get like one or two questions, and you can do it on the microphone, you have to do it in the microphone, so it'll record.
Pam,
I have no idea if the public really is allowed to question it about other topics, but.
I'm missing something. But my understanding was the gate lots, the fragment subdivided, which includes the applicant's lot, were all approved in that subdivision for single family houses. That was my understanding. So my question, it's a 26,000 square foot lot. It's not a small lot. So why would that be on the list to become R2? That's my question.
To the front.
All of our lots.
Too.
I don't know what year that subdivision was done. My guess is it was before sewer went up Stevens Street, when larger lot sizes were required, which was what got me involved in government in the first place, because there were documents put out that indicated that there were failing septic systems on our street. Shortly after a rezone had been done to downsize the size of lots that were allowed. And sewers went in, and then properties were allowed to subdivide and hook in. If that subdivision was done prior to that, then that would explain why. But I don't have all the
I don't
facts.
know the subdivision, right, it's okay.
Anyone else that would like to come forward to speak? Could we have our zoning officer come up and answer questions or let's give us a statement and let us answer questions. That's the question.
Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Norm, Roach, Norm, ROHCH. Part of the county office. Ask away. So I approved the permit as I interpret the code. As being a duplex and being grandfathered in to the R2 zone.
Any questions for the rest?
Why do you believe the use was grandfathered into the R2 zone?
Well, I had the list of the properties, I think it's 40 some properties, there's a list. And this lot was on the list. It was undersized, which grandfathered it in to the R2.
And you believe that included the use?
Yes, I did,
And-
or did.
Or did?
Well, did, you know.
A lot that was of a width of a frontage that would allow for a four-family unit. You have the view that that is permitted because it's grandfathered into the uses of the R2.
I would only, I would think it would only be for single family and duplex. It would have to be a single family or a duplex. I don't think I would approve anything over a duplex in that area. I would probably get some clarification on it either from yourself or the borough attorney or even our engineer before I would approve something that was more than 2 units.
How long have you been in zoning officer?
I've been full-time, I believe, going on 6 years. And part-time, I believe, 15 years.
Have you ever approved another duplex in the R4 zone because it was previously part of the R2 zone?
I think there was one, but I'm not 100% sure, but I believe there was one.
That's all my questions. Anybody else have any questions? The applicants are allowed to ask questions. Anybody can ask questions?
Other buildings in this design as a duplex?
In this zone or throughout the borough?
Both.
There's probably a handful of duplexes throughout the borough that's been approved with connections, roof connections. Not so much a common wall, but a common roof. There's
Common roof with some sort of structure
well,
enclosed.
a patio type thing, and I think even the board has approved some similar duplexes.
I don't recall. I only have 6 or 7 years in. I don't recall that. And the one I recall was the principal structure connected by a roof. But I don't recall. If this was connected with two 4x4 storage closets, so there was 2 houses and they each had 2 storage closets, and they butted up against each other, would that be a duplex?
I wouldn't consider that a duplex, no.
What is the structure that has to join the two, in your opinion, for it to be a duplex? If they just touched corners, would that be a duplex? If they were
No,
just,
I wouldn't believe so. It would be like a solid roof connection that would connect the two buildings together, whether it be a breezeway or a enclosed area.
thank you.
Questions? Okay, thank you.
Thank you.
No, We can talk to each other, you can discuss it, you can share your thoughts. Now everybody gets to
Public
go.
portion is closed. So,
What? Oh, do you want the attorney sum up here? Oh, you want to hear? Why don't you listen? The attorneys want to sum up. Do you want to have a discussion among yourselves first, or does anybody can address that? Or
I think
why
we
don't you just sum up? Sorry, to yourself.
I actually think, do we have some discussion amongst ourselves? I mean,
You can.
yeah,
You can get up before or after they sum up with it. You're the chairperson. You decide such things.
I've always interpreted these, I live in that area too. I'm a grandfather. R2, I have a 50-foot frontage. I've always interpreted this to be the use at the existing time. I agree with the use of at the existing time, a single family lot would not have all the uses of the R2, I always thought. And also, properties that were not previously subdivided were now subject to the new lot sizes. So if you owned 150 feet, you could not have 3 50-foot lots. You have one lot now because you never subdivided before that time. I don't see it as just continuing to me it doesn't make sense to switch it to R4 if almost the entire R4 is grandfathered to still be R2, is what I'm trying to say. And I've always understood it the other way. Yeah. It just sounds different than we've been approaching this in things that have come before this board in the now R4. And we've heard several things that have come before us where we interpreted it that way. Anyone have any thoughts?
I guess, I mean, maybe I'm asking a question related to what you said, but I'm thinking about, have there been, here we're talking about a duplex. Have there been any other cases in any other zones with the changing of zones? And this is a pretty big question that covers a lot of research. I don't know if anyone's done it. But do we have any precedent that's relevant at all about a use? Could be different, could be an accessory, whatever it is, that held in a similar case, like through the changing of zones?
I don't claim to be a total zoning guru. I've never seen anyone do an ordinance like this. I've never seen, and maybe other attorneys have, but where they've kind of created a new zone and kept all the uses and the sizes of the prior zone for the prior lots. I've never seen that. Doesn't mean you can't do it. I'm just saying that it's not out there. I haven't seen it in council. I've had a month to find it. So
Okay, so
I think
just
we're
be
in
clear,
creative territory.
you're saying you've not seen it anywhere in your experience, like, around the state, but also specifically not in this borough?
Well, I know I haven't seen it in this borough.
Okay.
I am not in a position to tell you what's going on throughout the state. My zoning experience is limited to Cape County.
Okay.
Some ocean and a big racetrack in Woodstown. But other than that, I'm just telling you that's not typically how zoning is done. In fact, it's a little. I don't even know if this was done as part of the master plan, which is usually when we do these kind of things. Was this part of the master plan? I don't think so.
Yeah.
It was part of the master plan to do.
Was it the years or
I don't know.
different?
No,
2001 is this, but.
I don't have any precedent to offer you that would be helpful in your analysis.
Okay, that's, I'm just seeking.
Fair question. Council does the statement of summary.
Anyone else on the board have anything?
I guess the analysis by Norm Roach in regards to a roof line structure connecting the two principal structures for the duplex is something that we approved in the last 18 months. I do recall that it was a screen porch.
Out of 2 months.
wasn't a duplex. I just remember that.
It was a single residence that he wanted to have with his quarters in the back for the rest of his family. And he connected it, and we specifically said that it cannot become a condominium and be in separate ownership. It's one household. But I thought it was two principal structures. And then they kind of made it look more like a single family by making the walls and having screens and
So-
that. Other like, it was at the time 2x4s, two houses or two different units, and they were the two principal
It
structures.
wasn't a duplex, it was a single family.
It's not a duplex.
And I voted against that.
That's what helps my brain remember that. Okay, thank you.
So we've got two primary issues here, right? So one, you've got the duplex issue, which we keep encountering. We've got to, in my opinion, we've got to clean that language up. The second is this grandfather. So if that's not binding in a sense, I do think we owe it to the community. If we're not going to adhere to the grandfathering, then we need to make that clear. Because we've got documentation, according to this anyway, it's documented or incorporated into property files that this grandfathering exists. So people, it's reasonable for them to rely upon it.
Grandfather
No one disputes his grandfather, the question is what was grandfather.
use, bulk versus use.
Right.
And that's a hard question.
Yeah.
There's nothing further, I guess we'd like to hear from both parties. Final.
Traditionally, we go first and last, so let's stick with the trial.
Thank you.
We appreciate the board's time tonight. I know that this was a little bit more complicated than what we're typically looking at, and we appreciate the effort and the time that everybody's put into it. A couple of comments, specifically the things that came to me while I was listening to the public. I think it's important to keep in mind that you heard comments from the public about consistency with the neighborhood or traffic. We're not here seeking variance approval, right? We're just here because somebody filed an appeal of a zoning permit that was already issued. So the decision that you're making is whether or not Norm appropriately issued a zoning permit for the grandfathering of this use. You're also making a decision about whether or not the design of this home meets the definition of your duplex code, which again, we believe that it does. I understand that perhaps that language in the code needs to be amended and that it might not be what you want to see duplexes look like, but this is, it meets the technical definition of a duplex in your code. The other thing I wanted to clarify is I went through the grandfathering list when I was sitting over there, and there are only, the grandfathering list lists a frontage and a deck. Keep in mind that those R2 uses that were grandfathered, they still have to meet the bulk standards that were under the R2 zone. So these lots that have 50 feet of frontage, you couldn't build a duplex on them. They don't get the benefit of a duplex because they didn't get a duplex in the R2 zone. So when you talk about 66 or all these acres, there are 31 lots on this list that have over 70 feet. So those are the only ones that are subject to this use issue. So we're not looking at 70 lots that this applies to, and it's only been done once. It's 31 lots. The other thing to keep in mind is when we talk about precedent, and have you ever seen this before, you've seen this in your own borough. The borough has issued a permit for a duplex on a lot that is grandfathered in the R2 zone. That's the precedent that's been set. And again, we've heard from some of the public about not liking the design or minimizing growth. But what you've also heard from is your zoning officer, who talked about what the history is here and what the intent of the ordinance was. And you've heard from a commissioner who has personal knowledge of this. That was her intent when she voted on it. She's also here as a member of the public saying, yeah, that's my understanding. That's how it's been interpreted historically. And that's Norm made the right call. So I think when you're looking at those things, it's okay to keep in mind that, you know, this time may not be what we love on a duplex, maybe we need to fix that. But this is not some outlandish number of properties that are impacted by this. It was a select number that were put in this list with their lot and depth, or their frontage and depth in the list, so that everybody in the future could determine what was an appropriate use on the site under the R2 zone. And again, we appreciate your time. I know that this was. Thank you.
Thank you. Mr. Bell?
Thank you. Just a few things. So I want to be very clear about something. You know, at one point, Mayor Cather was asking about how many lots, and I got up and said, well, the meeting minutes said, but you actually have, I think she said the meeting 35, you have the list, 61. So there's 61 lots on the grant. And that's in the engineers. And also, again, with great respect to Mayor Cather, and this won't be a surprise to Mr. Hanley or Ms. Newcomb, because I sent them the law on this before. And actually, something I know from personal experience. So when you're talking about the intent of an ordinance or a law, what you cannot do is call the legislators that wrote the law and say, what did you mean it to mean? And there's cases that say that. Once upon a time, when they had the privilege of serving the blanket laws, the land county was free. We got sued over pay play, because the contract was 8 to 1%. And it was an issue of what the ordinance meant. And they trotted out former freeholders who had written the ordinance and tried to get them to testify. Well, what did you mean it to say? What did you want it to say? And the court said you can't do that. Can I ask our lawyer?
Yeah, I'd like to get a really solid answer on that. Mr. Bell, there is authority for that proposition in the legislature, which is made up of a huge number of members, or maybe how many are in our state legislature, Mr. Bell, you can probably know better than me.
47 or 87.
40 senators, 80 something. Whether that applies in a small borough where you have 3 people who passed it and a 2-to-1 vote, and the one of the 2 people says, I know this isn't clear, but this is what we meant. Can I say that that's not something you can consider? It is. But in the end, 2 things are important. First,
I'm sorry, I'm gonna interrupt you. I just want to know that aspect in regards to the state statute, like if that's.
that authority is uncontroverted.
Okay.
That's the authority to the contrary. And I also believe there was a general sense, whatever. Okay, you can't just run around and ask them, 400 members of the House of Representatives what they really meant. That's why we write this stuff down.
Very specific reason why I'm asking that question.
Yeah.
Okay.
Okay, so you're really not supposed to do that. It's dangerous territory, because you haven't told to the other person who voted. The other person who voted may say, well, that's not what I intended. I thought I was doing the other thing. So you don't really know. Maybe it's not. One there or that. But is it relevant to think about and talk about in a small town with 2 people? Yes. But it's not determinative. So I don't think you should say, well, Ms. Cather said that's what she meant, so that must be what the ordinance says. Also, this is tough on the ask planning board. It's asking you to judge it. Okay, you're not necessarily trained for that. All right, that's I get it. You really don't go too deep into intent if the ordinance is plain on its face. So if you read the ordinance and the ordinance is clear to you in whichever direction, okay, I'm not suggesting a direction, then you don't get into all the ancillary things about what people may have said or what they intended, and readings of other committees and what they've done in the past. If it says, restaurants are not permitted in the zone, you don't start thinking about, well, what do they mean by that? They mean restaurants aren't permitted in the zone. You don't get into the intent. And I said, once it's clear, it's clear. So you may decide, this is really clear to me in one way or the other. And I hear the intent and all that, but I read this and this is what it means to me and I understand it. And that's perfectly okay to do. And that's part of what lawyers and judges do all the time. Mr. Bell and Mr. Newman and I are always trying to tell the judges what a statute meant, and the judge will say, I don't need that. I know what it means. I'm reading it, and it means this, and it says that. That's the end of it. That's not, or a contract. Sometimes contracts are so clear, it doesn't need backup information. It says what it says. We're closing on March 5th. Whether you meant April tenth, I don't know, but it says March fifth. So,
Sorry to interrupt you, Mr. Bell. I just think that
yeah, I had to explain it to everybody later anyway, so I've done it now.
Yeah, to understand, and I'm sorry, that was a case against a 4-3 holder, so it wasn't a municipal government. But what I was gonna get is, you don't really need to delve into that, I was gonna get into what Mr. King was saying, is that the language of the ordinance is plain and unambiguous on its face. It says that bulk and area are preserved. It does not say use. What it says to use is to the extent of the development existing at the time. At the time the ordinance was passed. At the time this ordinance was passed, this was a vacant lot. So it gets the benefit of the bulk of the R2 bulk, but it does not get the benefit of any use in R2 we didn't exist at the time. We have pre-existing non-conforming uses for all sorts of things. That's what you would have to get to the qualifying. The use was not preserved. Again, for what I think are fairly logical reasons, there really would be no point in amending the ordinance if you just do everything that you were allowed to in the R2. Why take those uses out? There's still be no reason to amend the ordinance. If we are going to look at intent, again, the ordinance itself says what the intent was: preserve the rural character, preserve that nature of development in that area. It would be inconsistent with that intent in the ordinance itself. Why the ordinance itself says it was being passed to allow multifamily here when it's a conscious decision made to delete it. So again, plain language, I think that ends the game. Even if you get past that, looking at what the ordinance says its purpose is, and what the logic would be as to why we do that is controlled. As to the duplex issue, again, I think it's really been covered. But the point that Mr. King made about the definition of dwelling and dwelling unit, right? The dwelling unit being the living areas, the sanitary areas, that is what consists of a dwelling unit. And those dwelling units are not contained, which is why this duplex interesting to me. And I know there was an issue with the DEP permit where it was issued for a single family home, right? And then they sent an email saying, no, we don't really care. It can be a duplex as long as it's in the same footprint. Must have been particularly accommodating that DEP sent emails amending the permits before, but it's interesting, and when you look, I gave you the definition of duplex, the DEP uses, right? In the letter that I set forth, and I think Mr. King mentioned that too. So their definition of a duplex, when they're saying we're okay with the duplex, are they using the DEP definition of duplex, which has to be shared wall or top and bottom? So,
Well, I think it's, can you read that? You have it?
the DEP definition.
No. Yes.
Yeah.
You can say on board.
A residential structure of 2 attached units in which the interior living space of one unit directly abuts the interior living space of the other unit, either in a side-by-side arrangement sharing a common wall or in a lower unit, upper unit arrangement. Is how DEP defines duplex. Under the specific regulatory provision of this plan decision, 7-1, 7-1, which is also some answers. So what you have here, and again, this is really, it is up for interpretation. Can you just have 2 single-family homes and you can touch them somehow, and that becomes a duplex? Or does it have to be, under your definition, with the dwelling units, the rooms that contain the dwelling units, the living space, the kitchen, the sanitary areas, have to touch and be contained in one structure to make it a duplex? I submit to you that definition better fits with your zoning ordinance. And that this would, even if a duplex was allowed, you really don't, I guess, have to get to that question. If you decide that you need a use variance to put a duplex, you really have to decide the issue of what is and what is not a duplex. Although I'm not going to tell you how to structure your things. It's our council. If it is allowed, they decide whether or not this actually decides that issue. But if it is going to duplex.
Thank you.
Well, On the issue of what this ordinance intended, I have no comment on that. We're gonna have to decide that you have all the information you need, and I don't wanna take a side. To the extent my questions and brought out aside, maybe they do, I can't help that, but that's the questions of both sides. On the duplex thing, and this is not directed to this particular applicant, I've said this in 2 different municipalities, and I've said it in prior applications. I don't believe this to be a duplex. I don't think simply having part of the house is touching is what a duplex is. I think the term containing is an architectural comment. I think that the definition of dwelling unit speaks of interior living areas, and that is what's supposed to be touching, and they're supposed to be contained in a structure. Contained, so it looks like a building that has 2 units in it, not something that has a 40-foot hallway connecting 2 houses, or a myriad of things. One of the members of the public said, "Well, I have 2 houses. Oh, I can't have 2 houses? I'll connect it with something." What is that connection? To me, the definition of dwelling is living space, and living space is, to me, not the garage is touching the big hole above, whatever the case may be. That's just my opinion. You may disagree. The DEP agrees with me. I had Colin read the whole definition. The thing he didn't say the first time that was in it when he read the whole thing was the interior living space aspect. That's what the wall's touching on, an interior living space. So maybe these folks can build a duplex, but to me, I don't, this is not architecturally retained structure, and it's very dangerous to let things just be some common living space in this that architectural. Doesn't make sense to me. But your ordinance is not very good, and it's not very clear. So you need to decide whether this ordinance can be read in a way that lets them do what they're doing, and maybe it can, because it's not a very good ordinance. Somehow you have them contained in those definitions. The engineer completely disagrees with me and says the opposite. So obviously the reason people can disagree on that, and he's an engineer and I'm not.
I'll play quick devil's advocate. Like they read the DEP description of what a duplex is. We're looking at an interpretation of your zoning ordinance. Your zoning ordinance reads right here. So in this configuration, you have technically the living quarters, a garage, and the living quarters here. If they flipped it 180 degrees and you had a garage, living quarters, and then garage, it essentially be the same footprint, the same structure, one structure with 2 living quarters in it. I'll die on this hill. I think it fits that definition of your zoning ordinance. If you want to change that in the future, it's something we can discuss where it needs to have some kind of shared living party wall, is what they call it, where it's a living room abutted up against one another. If that's, again, if this structure was flipped 180 degrees, does that make it a duplex?
So then the living dwelling units would be contained in a structure, would be all in one block together with a couple of little things inside. Except, but that's, I get it, we don't want you, that's not. Okay, so what we're gonna do is, to be hyper technical, what you are voting on and what we're gonna vote on first is whether or not, I'm gonna think for a second. I believe that there are 2 errors claimed that the appellant claims, Mr. Bell claims that your zoning official committed 2 errors. That's the word that the ordinance used, committed an error. 2 separate errors that they claim. The first error is that they don't believe that a duplex is a permitted use on this property. Okay? So you're going to decide whether your zoning officer made an error interpreting the grandfathers of the permitted use. All right, and before you vote, I'll clear that up so I know exactly what it is. Second thing you're going to vote on is whether or not you made an error in deciding this particular structure is a duplex. You're going to vote on those separately. Because if there's an appeal, I want the judge to know how much you voted on each of those 2 things. Also, for the applicant, if they win the first one and lose the second one, then they can have a duplex. They might just have to build it differently or something. I don't know. But there's also a request for an interpretation. I get that. it's all lumped in there. As you decide this, you're interpreting, so I'm not gonna torture us and make it do it all different. You're interpreting as part of this, okay? They did the proper thing by requesting vote. I think they did also, I mentioned it, and made them give notice, so that was good, but you're interpreting. If they lose, if for some reason the applicant loses, they do have the ability to come in for a variance. Explain why this particular piece of ground is well suited for a duplex, whereas other properties may not be. Okay? That was something someone talked about, so I want to clarify that for you. You're not voting on that tonight. There's no application for a variance for you tonight. That would be a separate application if they made it, and you'd have to go through the whole process. So first, I'm going to ask you to vote whether your zoning official made an error in allowing a duplex to be a use in R4 zone. Okay, so if you agree with Norm that they could, I want to make this right. So you're either going to affirm or reverse the zoning officer on that issue, on the issue of the use. Okay, so you're either going to agree with Norm or disagree with Norm. Norm Roach found that they could build this. So if you agree with Norm and you believe that they can build a duplex in this R4 zone on this property, you're going to vote yes. If you believe they can't build a duplex in this R4 zone, you're going to vote no. So yes lets them build it, no means they can't. I think that's the clearest way. Okay? Yes means they can build it, no that means they can't. On the use issues, we're going to vote whether it's a duplex next. Okay? So the motion I recommend being made is a motion to affirm the zoning office decision. Yes means they can build this use, no means they can't build this use.
Can I ask a question? So are we saying that if we vote in the let's present this, right, and say an error was made, in effect, on that first vote, are we nullifying the grandfather?
No.
Exists
Oh, no, you're just saying that the use isn't part of what was grandfathered. But anybody who has an undersized lot, that's undersized in the R4, if it wasn't undersized when it was R2, they could still build a single family.
Okay.
Because single family is a permitted use in the R4. But the bulk thing, I don't think anyone is arguing that the bulk is grandfather. Everyone agrees that bulk aspects grandfather. Bulk meaning lot area, lot width, whatever else, side yards, whatever else you deal with. Okay? That's just a use issue, is what we're at issue tonight. Okay? All right. So that's the motion I recommend you made. I'll make the motion.
I'll second the motion.
Barnes,
No.
Fusco,
Are we able to make a small comment?
I'm encouraging you.
Yes.
Yeah.
You should give your reasoning, and if you have a question about
follow up.
what yes or no means, then you can ask me. I don't want anybody to mess me up. If you make comments, I'm open.
So my reasoning is, the ordinance is unbelievably clear in regards to the master plan, sustainable development, preservation of open space, agricultural land. It's so in your face in regards to that I understand that the area and bulk zoning, there is no question with that, but the use, is under question, and I don't believe that it was interpreted correctly, specifically because of what you said in regards to I would have been swayed by some testimony, but mentally I struck that testimony from my head. And so I believe that there was an error. So my answer is that.
Fusco,
I agree with the borough engineer. For some context commentary. I do also think it's clear from the intent of the new zone what the goals were. But in particular, I'm fixated on this sentence here that I've read many, many times, and It says it is the intent of this paragraph that those lots and uses existing at the time of this amendment be preserved as pre-existing lots and uses. And that to the extent of their current development, they retain the benefit of the zoning that existed at the amendment. To me, that says that the use must be existing. And I understand the right to apply for variance, but on this, I say no.
Morgan?
I'm also gonna say no. It's fine. The master guy.
Richard?
Similarly, I'm gonna vote no, and I do want to express my. I think there is confusion here, but I do feel, for the reasons already mentioned, that no is the appropriate vote in this instance.
Griffin?
I think that all the documentation is inconsistent, that it doesn't reflect that use is grandfathered, so I do have to vote no.
Ray Flynn?
I vote no also. The use, the documentation, it's clear that.
Roselli?
When I read the ordinance, I highlighted that exact portion, and I vote no.
So the board has determined that a duplex is not a permitted use in the R4 zone or a lot that was vacant. Decision the board can decide to make, although arguably it is due, if you want to not do it, that's up to you, is about whether or not, if this were permitted in the zone, would this qualify as a duplex? You technically don't have to decide that right now. Because you decided it's not, a duplex isn't a permitted use, so I leave it to the chairperson of the board as whether you want to dive into that in this context or not.
I personally think we need to re-examine our definition. I do believe our engineer in both cases, but since it's a moot point, I don't think we should decide on that. Do I have anyone else then?
I would second that.
Can I offer a comment?
Yeah.
Maybe we should. I mean, on the surface, I completely agree. It is new, right? But we keep kind of coming up with having this debate when these types of topics come up, and I'm wondering if we shouldn't.
This is,
Yeah, I mean, it's just,
What the
sometimes
definition
you want to do your planning, you want to do your planning, and you're deciding, and you're deciding.
obviously, there's a problem with our current definition of duplex. That needs to be fixed, and it's probably is a good place to do it.
Okay.
Right, you made all the decisions you're required to make tonight. And you're sitting as a quasi judicial board, so you probably shouldn't talk about it if you make a decision, so. Madam Chair, anything else on your agenda
Yes,
that you want to do tonight?
just a brief note about the master plan reexamination. I think everyone on the board received an updated worksheet. This has been audibly discussed at the 18th, February 18th, was that the date, or was it January actually? Well, the first, the work session that we spent several hours going through the initial document. This is the latest one. This is after 2 conference calls with several.
Excuse me, I'm sorry, we're still on the record. Can you keep the noise down, please? Thank you.
Just wait.
Any discussion can be taken outside of the courtroom. Thank you.
just gonna take a 2-minute break.
Or we could take discussion outside of the courtroom. Thank you.
Take it easy. I'm gonna go.
It's also nice to see. She looks sweet, she's
Little. Oh, sure. Either one of them looks like Santa. Little boy.
We are still live streaming, FYI. That's right.
No.
It's,
Just lose that's. And I see that personally voted against that second. Second night spread.
That's around the question.
That's R two. So they're allowed. That's not. That's why. You're new to that you never had to. Pretty soon, if we have to use those boats. Pretty soon, you'll be able to use those boats and rent there. Election doesn't. And then, so you don't see, it's kind of, it's the phone and everything. That's a lot of things now that. All right. That was too different. Okay, guys, back to this. Rather than go through this tonight, which I'm sure no one's up for, everybody got a copy of this, and this reflects the 2 conference calls that were both in excess of 2 hours each. That several of us, on my way down, Fidelity Associates, and they've updated this with our concerns so far. We still have a couple areas that we wanted to get a little further into. I think most of it was regarding business, the business district. But if everybody here, rather than go through this together tonight, could go through this and get back to us with concerns or comments. But it's been updated from that first one. This is the 3rd one or 4th one? 4th-ish, yeah. So we are moving along, yes.
So just if I try to summarize this, like big picture wise, this is the result of, the several meetings that we've had, some of the public commentary, everything. The
So
first
far.
version of this, everything's sort of been updated and summarized into sections like this.
So far.
So far, right, sure. And then we're gonna we can add some additional comments to that. And then of course, surveys will go out soon and there'll be more public comment and this will continue to get amended. This will sort of serve as like a structure for writing the.
Correct.
We're working on, I think, round 6 of the survey.
Yeah.
Okay.
Hopefully.
And that's something.
Hopefully, yeah, hopefully we can get that.
As soon as the survey is launched, I will send it out to you guys, the link to you guys directly, so you'll be able to access it right away, but it will be on our webpage, like on our homepage of the website, right?
What is the red highlight, for those things that you guys don't like sections on, like you need to focus on this?
Those-
That's cheap.
These were changes, it's like a red line here. So those, that's. Super.
Yellow.
Some added stuff, added, yeah.
Most of the change sections labeled sustainability, which was at the end of.
Yeah, that word was used and bantered around as much as mills.
Right, so.
Even though I think it was just coming into a conceptualization of what that meant.
And I have one comment from historic preservation.
Absolutely.
I was reminded this week that we are going for a grant to add in new additional base surveys of different properties throughout the borough that we will be able to more appropriately deem additional historic homes to be added, possibly added to the historic district throughout the year.
Thank you. Yeah, and Jim, this doesn't, even though that any expansion of the district is not happening immediately, surveying those houses will make that expansion easier when it's discussed. So
That was one of the big issues
Yeah.
that we faced when, I think you were, where are they going to be, whether they're going to be, how much,
Which ones?
right, which ones, so we had to make a determination.
So it's not just considered.
Have so many, we'll have so many houses surveyed, and then from that survey, we'll select the correct ones.
That makes sense.
Yeah, so they're not spot picked.
Yeah, not just random and right selected, right, so set criteria, this is one, this group, this big.
Right.
So it'll be assumed.
It gets put in front of commissioners for their reviews and approval of public comment. And then they approve the ones that are so.
Any expansion of the historic district would have to go through an ordinance change. With introduction from here to this floor.
See, plans about facilities that are not being with.
So they did with an ridiculous, yes. Well,
It would all be connected.
not necessarily.
There are individual homes that are going to be proposed. I couldn't give an example off the top of my head, but it's not a streetscape. It's not an entire street now because of the development and because of the houses that have actually been renovated or knocked down that are no longer there. So it might not be a continuous streetscape. It might be for here. No, one, you know what I mean, like something like that.
For example, kind of like the 1920s cottage style houses that exist. They're now 100 years old, and so we're at a different look back historically. Then
That was maybe my second
Yeah.
question, is what is the criteria?
yeah. And again, if Elon was sitting here, he would say 1920s to 1940s up till then at this point, because it used to be, again, taking back to, this was 34 years ago this week I bought my house, but you were looking back to a 100-year-old house at that time, 1860s, 1870s, that was considered historic. Now we're inching well into the 21st century, so you're looking at a whole different segment of houses that,
Some craftsman cottages,
Yes.
things like that.
I just wanted to add that Pinoni's been really great to work with. They're really great to work with. So, is there anyone else that has anything?
All right. Do you want us to email this back? Is there like a date?
Anything you have, you can email to me, and I'll get it as you go.
I mean, I would try to say the sooner the better.
Yeah,
If they're trying to work pretty diligently.
Do you have an idea how many applications they have for the?
Next meeting, April 1st, we have one application.
Is there a preferred format for feedback? You want, so do you want to embed comments right into the spreadsheets? Do you want us? If you just list out in bullet fashion, like what makes it easier for you? Because I would imagine you don't want it 8 different ways.
No, I mean, so there's a header for each
Yeah.
kind of section, so if you want to
Just
kind
put
of
the comments right
header
in.
it. If you want to, anyway, I'll figure it. And if I have questions, I'll ask you. So
You plan on talking about this again for the next?
So saying, we only have one application, it might make sense. I mean, it would make sense.
So that you said the next meeting, not the workshop.
Right.
That would make sense.
Planning meeting, yeah, because I know Benoni is, they were questioning the need for another conference call, or can we just do this with comments? So as quickly as we can get those comments to them, we can finalize that document.
I do have recommendations for revisions to the zoning ordinance, like definite multiple definitions, with lot coverage, the front porch issue that we brought up next. Don't know if
Great.
you want to introduce those at, I can prepare something.
Yes.
For next.
And I think that's something that Matt was working on too. Like, so I don't know if you want to get with Matt first, because you guys might have a lot of the same.
So does anyone have anything? If not, let's just make a motion to.
The next meeting or the next, sometime in the next month, we want to push through an emergency definition of duplexes.
I don't want to. I don't want to push through, I want
I
to
think we should have a discussion.
We're gonna have a
speaking.
discussion.
Right.
We'd have to amend things on. Right. Not gonna push anything, but we do have to. Discuss.
I think it takes 2 meetings of the council.
Right.
Once you do that.
But actually, in this past couple of weeks, looking at the definitions, there's some really standard ones that seem like pretty simple and really, I think most of us are thinking that's appropriate.
Or we can just align with it.
Which is very much like the other
Think
ones,
that
yeah.
way.
Are they the document principle, or the definition of the law?
But they have access to every ordinance in the state, so I mean,
Well, I'm just saying, is that the guiding definition or what would be?
I'll look at surrounding communities, I'll include the DEP and they're all in one or 2 pages, just.
every definition I've seen is better than bad. Well, it doesn't even talk about things side by side and top and up. I mean, almost all of them talking about being side by side and up and down. What's that?
Everyone's eliminate duplexes altogether.
No.
It's like, they're not gonna argue about it.
Just takes 2 minutes.
By the way, the definition wasn't at the DEP level, it was for, and seeing as how we live here in the CAFR zone, that's the CAFR that was the CAFR delta, just for clarity.
Motion to adjourn.
Sure. Second. How's it going? What's the craft? Bunch? Yeah.
I am so, I would think everyone loves